Hey everybody, we've got some big news. The Fifth Circuit just ruled against us, in our case, McRorey v. Garland. And so where do we go from here? Well, there's only a few options left, and let's talk about it. I'm Phil, and you're watching Law and Ammo. But before we get into that video, I want to take a second and tell all of you about GOA's first convention, Goals, the Gun Owners Advocacy and Leadership Summit. This first-of-a-kind event will be hosted in Knoxville, Tennessee on August 17th through 18th. And the best part? It's free for GOA members. And there's going to be a ton of stuff for the entire family. I'll see you there. Now back to the video. On June 24th, 2024, the Fifth Circuit of Appeals denied our request for an en banc hearing. After careful consideration, we're deciding to withdraw the case rather than appeal to the Supreme Court. So why would GOA do that? Well, it's a long story. First, I'll go over the case details, what happened, and then get into our next steps. Back in 2022, President Biden signed into law the Bipartisan Safer Communities Act, also known as the Cornyn-Murphy Compromise. And what you shouldn't forget is that a handful of Republicans were instrumental in passing that law. Among other things, the BSCA changed how background checks work for those who are in the ages of 18 to 20. In violation of their Second Amendment rights and simply because of their age, law-abiding American citizens are now subject to what's being called enhanced background checks. And so these enhanced background checks can last up to 10 days and involve checks into juvenile records, health records, and a lot more. Beyond being an attempt to discourage young people from owning firearms, a right delayed is a right denied. And so we at the Gun Owners of America knew that we needed to file a lawsuit over these unconstitutional and discriminatory background checks. And so because of this provision, 18 to 20-year-olds are looked at as a suspect class simply because of their age. The plaintiffs in our case, those who were affected by the law, didn't have mental health issues, nor were they bad people. Yet they were denied their Second Amendment rights just because of their age. Our plaintiffs were Kaylee Flores, 19, from Taylor County, Texas. Flores was delayed during the purchase of a 20-gauge shotgun from her local gun store. Then there's Hayden Haynes, 18, from Greenfield, Indiana. Haynes was forced to wait 18 days for the purchase of a rifle. And finally, Ethan McRorey, 20, from Montague County, Texas. McRorey, who's a corrections officer, was delayed during his background check process due to the new law. And all the plaintiffs in our case were subjected to unconstitutional restrictions on their Second Amendment right just because they fell into that gap of 18 to 20. And so we filed a complaint, also known as a lawsuit, in federal court on May 12th, 2023. And we filed in the Northern District of Texas and were assigned Judge Reed O'Connor, a George W. Bush appointee. And if the name Reed O'Connor sounds familiar to you, it's because his name's been attached to a ton of lawsuits related to the Second Amendment, with a lot of gun groups receiving favorable outcomes from his judgments. And so we asked for a temporary restraining order to halt the new law immediately, and then a preliminary injunction to halt the law until the case was decided. Our hearing was set for August 3rd, 2023. We flew to Texas and argued the case to Judge O'Connor. And on August 14th, Judge O'Connor denied our request for a temporary restraining order and a preliminary injunction. In his order, he reasoned that according to Heller, McDonald, and Bruin, background checks are presumably lawful. But there's just one problem with all of that. The Bruin decision requires the government to show a broad and enduring historical tradition that is analogous to the provision challenged in this case. And of course, there are no historical analogs to a restriction on 18 to 20-year-olds from owning a firearm. In fact, there are no historical analogs for background checks whatsoever. And so by designating background checks as presumably lawful, the court didn't actually apply Bruin. And we felt confident that the Fifth Circuit might see it the way we do. And so we appealed the same day on August 14th. Our argument date was set for April 3rd, 2024, and we were assigned a panel of 3 judges. Judge Jerry Edwin Smith, a Ronald Reagan appointee, Katharina Haynes, a George W. Bush appointee, and Judge Dana Douglas, a Joe Biden appointee. On April 26, 2024, the panel of 3 judges unanimously ruled against us, affirming Judge O'Connor's denial. In their ruling, the Fifth Circuit panel again referred to background checks as being presumptively lawful. Well, that's bad. 2 typically friendly courts both refusing to apply Bruin's historical test and affirming the constitutionality of background checks, even going so far as to say that a 10-day waiting period isn't abusive. So we appealed again, this time to an en banc hearing, hoping that the entire Fifth Circuit would hear the case. But unfortunately, on June 24th, 2024, we were denied en banc. And so at that point, we were left with a choice. We could appeal to the Supreme Court, but then that would risk creating even worse case law if we were faced with a loss. It seemed that even the most conservative justices just didn't want to deal with the unconstitutionality of background checks, and instead blindly supported them regardless of what the law says. So we're deciding not to appeal, to withdraw the case and get back to the drawing board on how to fight this issue. And so this is where it might get discouraging for some of you in the audience. But regardless of what some activists will tell you, there are more ways to fight bad laws than with lawsuits. Bad laws can be overturned by Congress. This can sometimes be easier than filing lawsuits because sometimes the courts will just outright refuse to take on long-standing gun control, like the NFA, or in this case, background checks. But it requires a coalition of like-minded lawmakers and activists bent on enacting the change that their constituents want to see. You see, judges are very hesitant to rock the boat. It's the same thing with lawmakers, but judges are concerned specifically about the will of Congress. If Congress makes a law that's challenged in the court, judges often have to consider if they are legislating from the bench in their decisions. And so let's look at a hypothetical example. Let's say that there's a massive public outcry about microplastics, and Congress passes a law making plastic utensils illegal. While the companies may sue over the law, judges aren't likely to overturn it, as Congress is the legislative branch. They make the laws. Unless someone's rights are being violated by the law, it's likely to remain in effect. Here's the problem though. Unlike plastic utensils, you have a constitutional right to own a firearm. And that's why laws can be on the books for so long, and they're hard to overturn. Judges and lawmakers are hesitant to disrupt the status quo. Although if you create enough public pressure, an elected representative is likely to do something to make their constituents happy and raise their profile in the process. And this is also why elections are so important. Keep in mind that 15 Republican senators had to agree to vote for the Bipartisan Safer Communities Act. Out of those 15, 11 still have their seats. You have the power as gun rights activists to vote these people out. You have the power to hold them accountable. And for those of you who see this fight in Congress as just a pipe dream, keep in mind that we have been successful in recently overturning gun control with our allies in Congress. Just recently, we overturned an unconstitutional program by the VA, which was disarming veterans just because they had a fiduciary to help them manage their finances. That kind of tyrannical program by the VA affected more than, get this, 250,000 veterans. Now, this isn't a problem anymore, thanks to Congress. And so we have to move the Overton window in support of gun rights. And so that means getting more people involved in gun ownership and against gun control. We've seen massive changes just in the past 10 years. Imagine what we can continue to do in the future as more and more Americans continue to enjoy their Second Amendment right. Background checks are the sacred cow of the gun control lobby. Give them the power to expand background checks, and they'll make sure that they run as far as they can with it. We'll fight back in any way we can, but for now, it seems that the courts don't want to take up this question. As we promised when the law was enacted, we've challenged it in court. But this is why we can't just rely on judges and the courts. They're just as imperfect as bad politicians. And as for this specific provision of the Bipartisan Safer Communities Act, the 18 to 20-year-old enhanced background checks, there is a 10-year sunset clause. That means on September 30th, 2032, we're going to get another opportunity to dismantle this unconstitutional enhanced background check system via Congress. And of course, we'll be looking for every opportunity to insert a repeal to this law into some kind of must-pass bill, just like we did to protect veterans' Second Amendment rights a few months ago. Until then, gun owners of America will continue to push in Congress for a repeal to not only this provision, but the entire Bipartisan Safer Communities Act and all other gun control laws. All right, that's it for this week. I'm Phil with Law and Ammo. I'll see you next time.